Jasmine Crockett stepped into the Supreme Court expecting tough questions, but no one expected her argument to hit so hard that Chief Justice John Roberts stopped the entire courtroom mid-hearing, broke tradition on live record, and publicly acknowledged her reasoning, creating a rare power shift that left justices, lawyers, and the nation watching in stunned silence. The courtroom was already full long before Jasmine Crockett stepped up to the podium. Lawyers sat rigid in their seats. Clerks lined the side benches with notepads and reporters packed the press row. When Crockett finally rose, the room did something rare. It quieted itself. She placed her hands on the wood and looked straight at the bench, not timid, not rushed, but locked in. "Let's be honest," she began, her voice steady but sharp. "This court is about to decide whether zip codes still get to write children's futures." A few heads snapped up. She didn't ease into her argument, she went straight for the nerve. "We pretend this is about budgets and local control, but what we're really doing is allowing poverty to masquerade as policy." Across the bench, a conservative justice shifted in his chair. Crockett didn't flinch. "If equal protection only applies when it's convenient, then it's not protection at all, it's permission." The room tightened. Crockett could feel Chief Justice Roberts watching her closely, measuring every word. She knew he almost never disrupted proceedings, and that knowledge only pushed her further. "Today," she said, "you don't get to hide behind polite language. You're being asked to confront what this system has been quietly tolerating for decades." Then she went where most advocates refuse to go. She named the precedent everyone tiptoes around. "This court once told families that education is not a fundamental right," she said, letting the words hang. "And that decision has been used as a shield to excuse neglect ever since." The air shifted instantly. Crockett leaned slightly forward, eyes locked on the bench. "But let's stop pretending that ruling gave states permission to starve classrooms and call it federalism." A few attorneys in the gallery exchanged uneasy glances. Crockett pressed harder. "You built this legal framework, you set the standards, and now when those standards expose uncomfortable truths, suddenly everyone wants to step back." Her tone sharpened. "That's not restraint, that's avoidance." Justice Kagan leaned forward and broke the tension with a question that hit like a warning shot. "Counselor," she said, "if we accept your framework, what stops this court from being flooded with lawsuits over every locally funded service?" Crockett didn't hesitate. She lifted her chin slightly and answered with controlled force. "What stops it," she said, "is the Constitution itself. Education isn't just another public service. It's the entry key to every other right this court claims to protect. Voting means nothing if you can't read the ballot. Free speech means nothing if you were never given the tools to understand it." She then laid down her framework, slow and deliberate. First, she said, there must be proof of structural inequality that lasts for years. Second, there must be clear evidence that those gaps directly damage educational opportunity, lower graduation rates, and broken facilities. Third, she said, the court's role is narrow. You don't design school systems, you enforce the constitutional floor you already created. This isn't about judges becoming school board members. It's about judges refusing to look away when constitutional guarantees are being quietly erased. A conservative justice cut in sharply. "Counselor, your argument risks turning this court into a national school board. Are you asking us to override local authority?" Crockett didn't soften her posture. "With respect," she replied, "state control does not mean state immunity. Federalism was never designed to protect neglect. It was designed to balance power, not to excuse harm. If autonomy becomes a shield for inequality, then autonomy has crossed the line into abuse of authority." Crockett then reached to her side and signaled for the court display to activate. The screen behind the bench lit up. "We've talked about theory," she said calmly. "Now let's talk about reality." A timeline appeared showing districts where students receive less than half the per pupil funding of neighboring communities just miles away. "Half," she repeated. A journalist froze mid-keystroke. She pointed to a slide of Brown v. Board of Education. "This court said inequality in education creates inequality in opportunity." That wasn't poetry, that was a constitutional warning. Chief Justice Roberts finally leaned forward. Everyone knew what this meant. He adjusted his glasses and delivered the question slowly. "Representative Crockett, your argument asks this court to make judgments about educational adequacy. Doesn't that pull the judiciary into policy decisions that belong to legislators?" Crockett let the silence stretch for control. "Mr. Chief Justice," she said, "judicial restraint does not mean judicial retreat. This court has never been passive when constitutional rights are threatened. Enforcing the floor is not activism. It is obligation. The real overreach is allowing extreme inequality to continue while pretending the Constitution has nothing to say about it." The courtroom didn't breathe. 1 second passed, then another. No justice spoke, no gavel moved, and then Chief Justice Roberts leaned forward again, this time not to question but to interrupt. "Before we proceed," Roberts said, his voice unusually personal, "I want to acknowledge what just happened." A visible shock rippled through the chamber. "In my years on this court, I have rarely encountered advocacy that so clearly connects constitutional principle, precedent, and real-world impact. Advocacy of this caliber does not just advance one side of a case, it elevates the work of this court itself. The impact was immediate. This wasn't personal praise anymore, it was institutional validation. Questioning resumed, but the tone was no longer routine. Justices from both sides went straight into the framework Crockett had built. Even those who disagreed were now arguing on her terrain. Within hours, the clip exploded. Law students shared it, professors posted it. The story was no longer just about education funding. It was about a lawyer who changed the temperature of the highest court in the country. When decision day arrived, Roberts referenced her framework in the official opinion, crediting it with clarifying the constitutional questions. Weeks later, Crockett stood before students and said simply, "Preparation beats performance. Discipline beats noise." Outside the courthouse, politics kept shouting, but inside something quieter had happened. Authority doesn't come from volume, it comes from precision, restraint, and courage. If this courtroom showdown changed the way you see power, justice, and real leadership, don't let the story end here. Hit subscribe now so you never miss the next high-stakes confrontation, the next shocking moment, and the next truth that deserves to be heard. Turn on notifications, drop your thoughts in the comments, and stay with us because the next battle is already beginning.